Good evening, everyone at Cape Breton Live TV. Thank you for joining us this evening. We are going live with lawyer Leslie out of Florida. I'm so happy that I met this woman. Just the work she's done. I've been studying or watching her work and what she's done nonprofit wise too. And I'm blown away, and I'm very grateful to have her on live this evening. So I want to welcome on behalf of our viewers, Leslie from just out in Florida. Leslie, how are you doing tonight?
I'm good. How are you?
Good. We seemed to work out a few of our sound issues last week,
Yeah.
but listen, we know we have about a second delay with our communication here, so sorry if I sound like I'm interrupting you at any point tonight. But let's give our viewers an idea of kind of our content, what we're offering them in this podcast. What's our mission in this podcast, Leslie?
I think we're going to touch on false allegations, CPS investigations, delay tactics, as far as those that are alienating children from targeted parents, and those are the main ones we're going to discuss tonight.
Yep. I also found it beneficial. I went back on a couple notes we had written a couple weeks ago, and I took a picture here. I'll just make reference to it to remind us. Yeah, how to navigate through delays in the court, of course. We were talking a bit about that tonight. It's also giving our viewers a chance to get on and join us while we're chatting here. What else we want to cover? Great chance to do a sound check too. Pro se support tips, style of litigation. How are you the one that moves the case along? How are you the one in charge to kind of keep the pace going? Understanding how to move the case with what's available. This is what we're going to be discussing in our 6-week series, you guys. This is our second one from last week. You can go back and review the last week too as well. Please feel free to put #replay. Understanding how to move the case, the basic rules of evidence, how to get evidence admitted, discovery, great way to slow a case down, understanding delay tactics, as we mentioned, understanding being ambushed, understanding that judges have heard the story 1,000 times. So some really great content to our viewers that are listening in. So invite you to grab a pen if you have. Feel free to put your comments in below, and we'll get Leslie to start off right away on the topic of false allegations, delay tactics.
Okay. I guess we'll start, with false allegations. Something that's come up this week personally for me is several of my cases. It will start out as a highly contested divorce. And if you read a docket, what a docket is it's all the filings in your case. And I really believe that if you study a docket, you can see trends. You can see the flow of the case. And usually, when these false allegations come into play, is when a parent wants to try and position themselves to get more time sharing, or you can call we call it time sharing now, but it used to be custody. So a lot of times it's a really easy target, and it happens a lot to fathers where the mom would all of a sudden come up with some sort of allegation, and the next thing you know, the father's being investigated for sexual abuse allegations, and it's really dangerous because you only need one person to say it happened. So and it's not like criminal court, where you have a real high standard of proof. In criminal court, you have to show proof beyond reasonable doubt. When you're dealing with civil cases, it's a lower standard of proof, so it's a lot easier to have somebody, I guess you could call them found guilty, but technically it wouldn't be found guilty of a crime, but they will still feel, the consequences of that allegation. So it's definitely used a lot in tactics when you're dealing with highly contested custody cases. I can't hear you.
That
That's
would
better.
be same idea. Then you're suggesting would be the CPS, getting CPS involved, peace bonds, anything to that nature would be other sources of delay tactics. I know you made reference to.
Well, there's a different. I mean, you can have it's hard to say. I mean, everything could be a delay tactic in these cases because obviously, until you get to the outcome you want, it's all just hurdles that you're trying to overcome. Um,
Right.
there's delay tactics. When I speak of them, it's more procedural. It's, can I get a hearing? Can I get in front of the judge? And I guess I'll transition over to that issue right now. Um, the first thing I always tell people, and I've actually talked about this in some of the videos, is you need to understand the rules of the county or wherever you are in court. What are the rules that your judge abides by when setting hearings? You have to
Okay.
find that rule book. Then you
Right.
also need to find out if there's any ethical rules that you need to follow. So before you even get to the place where you're going to schedule hearings, you need to know the rules. What would be
Right.
considered reasonable time for opposing counsel to respond back to you.
Mhm.
In most cases, it's going to be about 48 hours. When
Right.
you ask opposing counsel, if a hearing date is okay, how many hearing dates do you need to give opposing counsel?
Right.
Usually I give 3 hearing dates and I wait 48 hours to see if opposing counsel will pick one of those 3 hearing dates.
Yep.
And if I always leave my wording in an email where I will say, well, if none of these 3 work for you, counter me with
Yeah.
dates that will work for you. Because otherwise, if you don't say that language, they'll just say, oh, that doesn't work for me.
Right.
And then you have to turn around and say, okay, well, what does? So you
Right.
always have to be a step of the game. But basically, you need to try to push them in the corner to pick a date for a hearing, and they'll
Right.
always pick the last hearing date available because again, it's more delay tactics. So those are more procedural delay
Yeah.
tactics. More things that a party can do to engage in delay tactics is be really difficult during the discovery phase. When someone is going pro se, I don't usually see a lot of discovery litigation because a lot of
Mhm.
times people don't understand, if you're not a lawyer, how to do a deposition or
Right.
how to request certain production and things like that. So you get this more when you have an attorney in the discovery, portion of the case. But
Yep.
what will happen is if you understand, say that I do what's called a request to produce, and I have the other party has 30 days to get that to me. A delay tactic would be they would wait to the 30th day to get it to me, or
Yeah.
they would wait to the 30th day to object that they're not going to give it to me. Right.
Yeah.
So these
Yeah.
are all things that can immensely draw something out. So you really have to be on your game and you really have to be like having a calendar and when things are due so you can move this pretty fast,
Yeah.
through the court.
Yeah. And I was going to get you to share with our viewers pro se. So just describe what pro se is.
Pro se would be if somebody decided that they were going to represent themselves and not use an attorney. And,
Okay.
a lot of people are left with this option because they just can't afford an attorney anymore. Usually, when I see pro se, someone go pro se, it's usually because one, they've been financially drained from an attorney and they just are so angry because it really didn't get them anywhere and they
Right.
refuse to spend another dollar, or two, they just don't have the money. They can't get legal aid or assistance and they just can't afford an attorney. And so they're forced to go pro se.
Right. So you walk into the courtroom, you're not represented by a lawyer until an actual hearing date. That's when you could go pro se up to that point and then bring in a lawyer for the hearing. Is that what I'm
Um,
understanding?
I mean, no, if you're going to go pro se, you would actually go to the hearing without a lawyer.
Okay.
Now, do I recommend it? No, I don't. Not, just because there's a lot of things that could go wrong when you don't have that knowledge as an attorney.
Right.
But some people are they're forced to have to do so. But I would think that if you are trying to save money, a little tip that I would have is if you don't have money for the normal attorney fee, then do it pro se. But obviously get guidance from somebody who understands the law and the process. And then if you are going to bring in an attorney, bring them into a hearing, pay for them to come for a hearing if you can find an attorney to do that. But, to me, if you have to go to a hearing pro se, you
Yeah.
are really kind of setting yourself up for things that could go wrong. And it has nothing to do with the merit necessarily of your argument, but it could be little procedural things that you didn't
Right.
understand, like the rules of evidence and things like that, that are a little more technical.
Right. So then doing a lot of most of the work can really aid you to save money in the long run. If you're doing pro se and you're being guided to do the paperwork. And I do know that in East Coast Canada, to our viewers, we actually do have a handful of lawyers that do offer pro se. So if you are looking for that, you can discreetly message us. We'll give you the names of those lawyers that offer that. Saving money, though, definitely finding out what, as Leslie mentioned, the rule book. Now in Canada, I'm not sure what it's called. I'm sure it's called something similar, but she's saying go down to the courthouse. If you're considering representing yourself, grab the rule book that the judge has in your area at that courthouse and really go through that.
Yeah, I mean, what you would say is you would say to the assistant of the judge, some places they call them judicial assistants. You would say, I would like Judge so-and-so's procedure book, if he has one or if she has one. Okay. So you're looking for a procedure book on how to set hearings, what type of hearings are available, because hearings are how you're going to move your case. So if you really want to move your case, you need to know those rules inside and out so that you can put a stand when somebody's trying to you'll recognize when someone's trying to mess with you or use delay tactics.
Yeah. And what about case law, Leslie? Do you have case laws or a site you can go to look over case laws that would have similar parallels to, your situation or something that you can resonate with as a parent?
Well, you can go, I know as lawyers, we use Westlaw and LexisNexis. Those are two different lawyer resources that have all the case law, that you would want. I think Google, right. There's an entity or there's something in Google where you can actually look up case law as well. And I know Westlaw and LexisNexis, I think you can get those at libraries for free.
Okay.
I knew some of my attorney friends that couldn't afford necessarily when they were coming out for the first time practicing. It cost money to have a subscription to, Westlaw or Lexis. I know that they went to the public library and actually used those programs from the public library.
Okay. Now let's touch on CPS for a bit, because a couple of weeks ago you mentioned something I found very helpful, especially for some of our viewers that have possibly had to communicate with CPS. CPS, the main reason they're there, of course, is Child Protection Services. They're there for the safety of the child, to make sure that they're not being neglected or abused, correct?
Correct.
So when CPS, or if you should get a knock on the door from somebody randomly at CPS, the best advice that I found you gave was invite them in, or whatever. Tell me what you said that one day. Don't panic. I know that was your first words you said.
Yeah, I said, here's the thing, you can, first of all, you don't have to let them in if you don't want to. But the reason I say just to let them in at that point is because you want to get the case closed. And,
right.
To me, it's like if there's nothing to hide, just let them come in, do their thing. Where I might put a restriction is if they try to, say, interview your child alone. I would have reservations on what would they be saying to my child without my presence. I would demand to be present if they're going to interview my child. Those sorts of things I might not necessarily allow them just to come in and start, interviewing my children without my knowledge. But I would have no problem, letting them just come in. I mean, here's the thing, maybe your house is a mess or something and you want to clean it up. You could avoid it the first time, and then they usually will leave a card on your door. So just call them back and say, when do you want to come over, clean your house? And then you can invite them over. They'll usually walk through your rooms and just make sure everything is okay. So.
Yeah. And definitely communication with your lawyer at that point. I mean, letting them know, just documenting everything. I found that was a second great tip that you had, was there's nothing too small to document.
Yeah.
Photos, video footage, whatever you want. I mean, I know there was one case in Canada where an actual phone recording was, I don't know how it works, where you are, but a phone recording was actually used in the court case, and it was allowed in a parenting case, and it was proving evidence of, one of the parents not treating the child well, and the phone call was allowed. The recording was allowed. So,
well, that's something else you got to remember with with these sorts of investigations, and this also goes hand in hand with, say, a GAL that's assigned to your case, you are able to get hearsay in. And if
Yeah.
any of you guys, if you guys don't know what hearsay is, it's an out of court statement that is said, for a certain purpose of what you're trying to prove. And a lot of times a court won't let hearsay in as evidence, or in order to let it in, you have to have some sort of exception. But when
Yeah.
you have CPS investigations or you have GALs coming in, um, if you say that you had a recording of your kid saying something to you and you let a CPS caseworker listen to it, that's kind of an indirect way of affecting your case with
Right.
hearsay without it necessarily being admitted into evidence. So, you are going to get a lot of hearsay in those records. So if you want to get hearsay in, if it's going to help your case, I would be all over getting it to the caseworker and get it in that
Right.
DCF report.
Yeah. Yeah, important. Notes are important. Documentation. There's things you can do to definitely be proactive while you're going through this journey. Is what I'm learning in talking with you over the past couple weeks. Flat out, you mentioned it. You brought it up. You're flat out broke. You don't know what to do. This is what this podcast is for. Is to kind of help steer you in this direction that's good. But if you have any questions, viewers, I'm just going to look at our viewing board here and see if we have any questions from our viewers. Leslie, if you want to touch on anything while I'm looking at this, feel free to go ahead.
Okay. Basically, as far as when you are getting investigated with, CPS, it's extremely important because it is a process. And they do usually, if they're going to shelter your kid or something along those lines, um, what I see happen all the time, because I do have these cases where a parent gets their child taken, sheltered is what they call it, and then they propose a case management plan where that parent has to go through this case management plan to be reunited with the child. And 9 times out of 10, where things go wrong is the parent doesn't understand what is in that case management plan and what exactly is expected of them. A lot of attorneys
Right.
that are assigned to these cases have such a large workload. I'm not quite sure why it's not being conveyed to the clients, because I have come into these cases where there has been attorneys and the client has
Yeah.
no idea what they're supposed to be doing during this process. And
Right.
I have to go read the paperwork, and then I have to explain to them, and they're shocked, like, oh, I didn't know I was supposed to do that. So to me, if your DCF or CPS investigation goes to the point where the child is taken, make
Yeah.
sure that you are very much informed as to what is expected of you in that case management plan. Because if you don't comply to that case management plan, that's how rights are terminated. So it's very
Right.
important. So.
Yeah. To do that. I did get a question from one of our viewers, just a private one sent, no name, that's fine. Viewers, you can send in a message to my message machine, 902-305-7833, if you prefer to be absolutely discreet about your question. Question comes from a viewer who says, how to navigate through the delays from the court or acts. We talked about that. To your knowledge, are there any states that have or are working to improve the system? What important case laws, what strategies to resolve issues are tested and improved? Yeah, okay, let's touch on that. What's some of your more successful trending strategies right now, Leslie, even simple ones that you
Okay,
know of?
here's a simple strategy. I have actually taken my email and I put a link on my email to the ethics bar on
Yeah,
how to schedule hearings. It's my state board of ethics on what is
okay,
expected of opposing counsel. So every time I send an email, the ethics rules are on my email to remind opposing counsel. And
right,
actually that's been very successful. I don't, you have to put fires out everywhere. That's the
yeah,
biggest thing. You can't let anything slide. I mean, just this week, a judge recused themselves from my case because the judicial assistant wasn't allowing me, she was ignoring all of my efforts to book a hearing, but yet she allowed the opposing counsel to unilaterally book a hearing without even asking me whether or not I was available. So
right,
instead of me allowing that to just go on, I ended up looking up all the ethics rules for the JA. I looked up the ethics rules for the state, and I looked up, any procedures the judge might use. And I actually wrote a letter to the judge, and I told the
Yep.
judge that I'm not going to stand for this, that this is, they're not abiding by the rules of ethics. And what ended up happening is the judge recused herself from the case. And so
Right.
that unilateral hearing got canceled. And, I thought that was pretty effective. So you
Yeah.
got to be, you can't be afraid. You can't be afraid of judges. You can't be afraid of judicial assistants. Everybody tells you kiss their butt, kiss their butt. But to me, it's not about people. It's about justice. It's about abiding by the rules, abiding by ethics. That's what I follow. And that's what I would tell anybody.
It's a chess game.
It is. Absolutely. And
It really is.
it really is. And you have to always think 2 steps ahead. And timing
Yeah.
is everything. When you have a case, you have to think, because there's some times where you want to delay things. For instance, you don't want to go to trial if you're going to go to trial and your child is going to say, I don't want to be with you. Because even
Right.
if you prevail, the judge isn't going to necessarily always order the child, because there's a risk. There's a risk the
Right.
child might run away. So maybe you need things delayed so that you can, participate in reunification therapy and build that relationship back with your child. In those circumstances, you might be the one wanting to delay those tactics, and opposing counsel might be the one wanting to make things go fast. So you need to really look at it's like the entire situation, the entire case. You need to know when dates are. When is your trial date? When do you want your trial date to happen? And you have
Right.
to anticipate and really strategize this whole thing as to, it's all timing is everything in this.
So let's put a scenario, in front of you. I know we hear of it common. One of the partners, male or female, doesn't matter. One of the partners is delaying, let's say, a divorce settlement, knowing full well that using the child as leverage. No, the child can't come. No, the child can't come. No, the child can't come. Fake excuses why they can't come. The other parent is constantly reaching out. It's delayed. You're not hearing back anything on the divorce negotiation settlement. Both of you hopefully don't want to go to a hearing. But what at this stage would you suggest as tips or strategies?
Well, I mean, as far as, you mean if somebody's using a child as leverage,
Yeah.
trying to position themselves with how you write a settlement agreement? I think that's great foreshadowing as to what's going to happen after that settlement agreement is in effect. To me, that would be complete foreshadowing of what clauses I need to write in that settlement agreement to stop the parent from, whatever they're doing to stop me from seeing the child. So that's where you would write specific clauses in your settlement agreement, stating that, if if the parent is withholding your child, this is what you're putting them on notice to do. I mean, because clearly they're showing you that that's what they're going to do even before your settlement
Right.
agreement is signed. So, I mean, to me, that would just give me more reason to write a very specific settlement agreement to actually address those issues.
Right.
As far as, using that as some sort of leverage, I mean, I have a couple cases right now where people were coerced into signing settlement agreements just so they could see their kid. So
Yeah.
that's another issue where people end up agreeing to terms they never wanted to, because they were so afraid that if they didn't, they're not going to be able to see their child.
Right.
So those issues, now I'm having to go back and do what's called a motion to vacate or a motion to rescind the settlement agreement based on duress. Right.
Right.
So, my advice too is, if you do feel like you're in a position where you're signing something you didn't want to sign and you feel like you're backed in a corner with no choice, sign your name and put underneath signed under duress. Put it under there. Write it.
Right. I'm
So,
writing this down. Signed under duress. Okay.
yeah.
Yeah.
Let everybody know that you didn't want to sign it, but you felt backed in a corner and you felt you had no choice. That will help,
Right.
further, prove your case if you want to try to get rid of that settlement agreement in the future.
Right. Just looking at any other questions that came through here, and feel free to talk on anything you feel we might be missing.
Trying to
Yeah,
think.
just, one question maybe we should cover it one more time. How do you navigate through the delays from the court to the ex? or the ex. So the ex is putting up delay tactics. Is there any way to kind of speed up the process, through the court system?
Well, I mean, as far as delays, I mean, it depends on what is being delayed. Okay. If it's the child, say, is not seeing the parent, we'll just start there. If the parent is withholding the child, you need to know what to file immediately. Now, there's little things, depending on what type of hearings your judge allows for. Um,
Yeah.
in most of the counties in where I'm at in Florida, they have what's called a short matters hearing, or they can also call it a non-evidentiary hearing. Okay. And these are
Okay.
little 5-minute hearings. They happen every week. They're always going on. And it's very easy to get these hearings. If you need something to happen now, that's a great tool. For instance, if opposing counsel is not getting back to you on a hearing date and they're avoiding you, you could actually file a motion to compel the setting of a hearing. And you could
Okay.
show up at short matters, and you could say,
Right.
Your Honor, I've tried now for a week to get them to let me know, and they're avoiding it, or they can't decide on the length of a hearing. I say it only requires 30 minutes. They say it requires 2 hours, right?
Right.
So if you're in kind of like a impasse where you guys are landlocked and you can't get anywhere, use one of those
Yeah.
non-short evidentiary hearings to compel the judge to help you book that hearing. That's why I say it's so important to find out what type of hearings and what the procedures are for your judge. Because if those hearings are available, jump on them. Use those
Yeah,
hearings. Use
for
them.
sure.
Yeah.
Well, we have a lot of information. We have good content we got in tonight. And, I know we said we would plan an hour, but I mean, we don't have a lot of viewers asking questions at this moment. Is there anything you have to close with, Leslie, that you want to say?
I would just say that don't ever I've had a lot of people say to not, that they'll go to an attorney and the attorney will basically tell them, no, there's no hope, or no, just, like a real definitive answer that doesn't leave them with a lot of hope. Understand the legal system is like a sea, like an endless sea. Okay. There's always, if you're creative, you can find solutions. Never just go to
Right.
one attorney and let an attorney tell you this is how it is and this is the only way, because there's always exceptions and always ways to navigate a little bit differently. So just understand that there are a lot of avenues. Don't ever take, one attorney telling you this is the way it's going to be. Search and shop attorneys, just like you'd shop a car,
Right. Yeah.
And so that's one thing I think is important for people to know as well. It's not a black and white situation.
Right. Well, I want to thank you. Yeah, I want to thank you so much. You can find Leslie on YouTube under Lawyer Leslie.
Yes.
And you can also, she has a beautiful website. You can also check out her services. She is available. You can message her admin to book an appointment for a consultation. I just want to thank you so much for joining us tonight, Leslie. And I know a lot of our viewers enjoy sending in comments and questions later, anonymous. So if I get those, I will definitely pass them on to you for some feedback for our next podcast next Monday at 8 o'clock your time and 9 o'clock Atlantic Standard Time. Thank you so much for joining us tonight.
Thank
Thanks,
you.
Leslie.
All right, Rebecca. Thank you. Bye-bye.